And welcome to this episode of the Good Citizen Podcast. Today, I want to dive into the topic, what about constitutional rights at public school? Now, I'm certainly an advocate for Christian education. I talk a lot about that on the podcast, but stats show that approximately 90% of American children attend public school. That's true in Indiana. It is true across the country. So if we care about citizenship in the future, if we care about the evangelization, the discipleship of students, then we should care about the public school. But what are the rules? What are some of the legal standards about engaging with our faith at public school? What about teachers? What about students? What about community groups? And so today I want to dive into that topic, talk about some of the legal nuts and bolts, at least where the courts are right now, where the standards are right now, so you can be equipped if you're feeling called into that space. Also would welcome questions. I'll mention at the end of the episode where you can submit those if you have questions about this topic. So let's dive into that. What about constitutional rights at public schools? And here's the big idea for the episode. The education of the young has always been a battleground of ideas, and that certainly continues today. Beyond the general teaching of math, language, and science, there's a struggle over America's past and future and how we should perceive truth and even ourselves. This topic is controversial exactly because it is important, because it affects our kids, our students, our future. So in this episode, I want to take a closer look at the cultural struggle that's going on, the relevant constitutional rights at school, and a plan for engaging these issues moving forward. I am going to show a presentation, some slides, if you're watching on the video. So we'll take just a second here to pull that up. And it is interesting that the battleground of so many ideas right now is actually happening right in the classroom. Again, I suppose that has always been a place where things are controversial, where we're teaching the next generation. That's super, super important. People know that. And so this is where a lot of the struggle is. So a couple of thoughts is we're thinking about constitutional rights. We're thinking about engaging in the public school, what's going on in public education. I think a couple of cultural developments are important. The first one is two views of freedom. I've mentioned this before, but especially in this context, I think this is important. We have a number of new listeners. So what I mean when I talk about two views of freedom? Really important question these days is, well, what do you mean by that? What do you mean by that? Well, if the word freedom can be interpreted kind of two different ways. The first view of freedom, which I would argue is found in Scripture as well as in our founding documents, was an ordered liberty, or it is an ordered liberty. This means that we are free to build a society according to God's good design, that we're going to flourish individually and as a society if we follow that design. And so that's one view of freedom. But the other view of freedom, which is becoming predominant today, is a freedom from what I might term an open license, whereas the first view of freedom is an ordered liberty. The second view of freedom is open license. It is a freedom from any authority. I don't believe in God. I don't think he has any say in my life. And so I get to design my own life. We should design our society according to our own beliefs, according to our own desires. And that's what's going to lead to true flourishing. And so much of what's going on today can really be ground down to these two views of freedom. And kind of along those lines, if you've noticed, the LGBTQ movement, I would say, has moved from what I might term an acceptance phase, where it's more, hey, just accept us in public life. There's the same-sex couple down the street. You need just to accept them. There's a kid at school that is transitioning, and we just need to accept that. And it's going from kind of an acceptance phase to an enforcement phase. And I'll explain that more fully with some of the cases I'm going to talk about. Some of them you may be familiar with, but it's no longer, well, just accept us. No, you have to celebrate this with us. You have to agree in not just your actions, but in your words that this is true. And so it's not just acceptance anymore. It is enforcement. I'm sure you're aware of this as you see what's going on in culture, but it's important to kind of pull some of these ideas together. The next one is certainly parental rights. And I think the COVID pandemic had something to do with this as kids were at home. Many parents were just kind of looking over the kid's shoulder. We're all in the same space, right? And so we're hearing what's going on Zoom. We're hearing what's going on online instruction. And many parents became very concerned about what was going on. Certainly, as of late, a lot of the transgender ideology being pushed in the schools, the parents have stood up. And so parental groups are forming around the country. And so you have kind of this clash in between, well, who the parents and then public educators. And the basic question, and this is one I thought, surely this is not an actual debate, but it's essentially an open question. All right, who could do a better job of raising kids in this culture and preparing them for the future? The parents or the public education system, the state? Who's going to do a better job? Who has kind of ultimate authority in wrestling over the future of children? And so this is kind of an open question, one that's being wrestled over in public life. So parental rights are certainly important. The last one that I think is relevant here as far as cultural developments as we're thinking about public education is what I would consider a plural future. Now, you think back just maybe 30 years ago, maybe 40 years ago, I think generally what was proposed is that America would have a very secular future. We'd have a public square that was essentially cleansed of any religious influence. Everyone was just going to be an atheist. There would be no belief in God. There would be very little spirituality. However, that is not what is occurring. And last episode, if you listen to it, I was talking about the rise of the religious left. So it appears that America's future is actually going to be more spiritual. Doesn't necessarily mean more Christian, but more plural, more spiritual, in a sense that we also have individuals that are from around the world. Many of the immigrants to the United States are spiritual. They brought their religion with them. Many of them are Christian, but some are Sikh, some are Muslim, some are Hindu. And so what we're looking at, I think, as America develops, we're looking at a more plural future rather than a just secular future. So what does that mean for a public education system? So those are a couple of cultural developments, two views of freedom. These things are smashing into each other. Certainly in public education, worldviews are colliding. The LGBTQ movement is moving from acceptance to enforcement. Parental rights are increasingly a concern to many around the United States. And I believe that our future, where we are right now, it appears that America is going to have a much more plural future than a secular one. All right, so with that in mind, let's move into constitutional rights at school. And as I mentioned, I want to go through a couple different groups. I'm actually going to start with student clubs and community groups. And these are actually kind of distinct, but kind of one category. So the first thing that I'll talk about are student clubs. And student clubs are anticipated by a Public Access Act, which was passed back in the 1970s. Equal Access Act. And this law grants recognition to student clubs in high schools and elementary schools to school facilities, and it benefits regardless of the religious or political views. And so a student-led club can form in a public school, and if it is a religious club, it is entitled to all of the same benefits as a non-religious club. And so this law basically said, look, if you got a religious political club, you can't just boot them out of the school. You can't say, by the way, you can't meet because of your ideological or religious viewpoints. And essentially what happens if the school has a single non-curriculum related club, so it's not related to the teaching of biology or science or math, then you've essentially created what's called a limited open forum, and you have to place all of the clubs on an equal footing, regardless of their religious beliefs, regardless of their political views. That's what the Equal Access Act does. And so a couple of things here with these types of clubs is that, first of all, religious clubs must be treated the same as other clubs. So the basic idea here being that neutrality kind of cuts both ways. You can't just say, all right, we're going to be neutral to everyone, and then pick on the religious group and kick them out because they're religious. And essentially, there's been kind of a hypersensitivity to the Establishment Clause, and a lot of schools have been, if we have a club that's religious in here, is it somehow, putting the state's stamp of approval on Christianity over other religions? Which you think back to the Establishment Clause, it's in the First Amendment to prevent the United States from having a national religion. So allowing some students to gather to worship, in a student club that's voluntary. No, that's not establishing a national religion. So the basic idea here is that neutrality cuts both ways. You can't be hostile to the religious group, so they must be treated the same as other clubs. What's interesting about student-led clubs is that they can access school funding. They can access equipment if there is an activity fund or funds available to various student clubs. then the religious club can have access to that. Maybe there's a PA system or some other equipment. They can have access to that as well. And they may meet during activity periods. So if there are other clubs meeting on campus when this religious club is meeting, they're fine to do that as well. They also may advertise events if there is a way for clubs to advertise various happenings in the school. So a student club can do that as well. One key thing to note about student clubs is that faculty, sponsors, or teachers have to act in a non-participatory role. If it's a student-led club, meeting during an activity period, then the faculty or public school teacher that's there that has sponsored the club can only be there in a sense to maintain order. All right, they can't be the one leading, say, a devotion or worship. They have to be very careful in this particular instance. And again, as I said at the beginning, what I'm sharing with you is essentially just where the courts have landed now. Could I argue that a faculty member just standing up in a voluntary club where kids are gathering is not in any way establishing a national religion? Yes, I could make that argument. I'm just simply setting out where things are kind of as we speak for these types of clubs. So student clubs do have the benefit of things like access to school funding and equipment, being able to meet during activity period. However, you do have the issue of faculty or teachers that are participating have to be in a non-participatory role. The other option is what's called a community group. So if schools open their facilities to various community groups, they have to allow religious groups. And there's a very famous case, if you follow this particular area of the law at all, called Good News Club versus Milford. You're probably familiar with Child Evangelism Fellowship. I've been around for a number of years. Great ministry that is doing great work, as its name implies, evangelizing children. And what happened at a school in New York is the school opened up its facilities for various outside community groups to come in and hold events. But they told Good News Club, which is a ministry of Child Evangelism Fellowship, I'm sorry, you can't come in, because if we allow you to meet on school property, then we're violating the Establishment Clause. So CF filed suit. It went all the way up to the U.S. Supreme Court, and the U.S. Supreme Court essentially held what I've stated earlier. That's not establishing a religion. And by the way, neutrality cuts both ways. You can't be hostile to the religious group and kick them out of the school facility just because they are religious in nature. And so the Good News Club versus Milford's very strong precedent that if the school allows clubs to meet, generally these are going to meet maybe at lunchtime or after school, before school, then the religious clubs are allowed as well. It's important to note that, again, this is not a recognized student club. This is a community group that's essentially coming in. And again, I think CF, the Good News Club, is perhaps one of the best examples of this. And what's helpful about these community groups is that they may actually be led by a school teacher. Essentially, the school teacher can take off their teacher hat. They can put on, in a sense, their CF or community group hat, and they can lead that group. So it can be led by a faculty teacher, or coach. It can meet before or after school, perhaps at lunchtime. And essentially, school policy sets out whether community groups may meet at school. This is something that ultimately would be decided by the school board and your local municipality or school corporation. But the basic legal principle is, look, if they open the doors to any community group, and sometimes they'll say, well, we don't really have community groups that meet. Like, really? Like, they're dig into that a little bit, because sometimes there are groups that are meeting. They just may classify them as something else. So don't get stuck at a name. And I have seen instances where they'll tell the religious group, oh, by the way, we don't allow community groups, but there is one meeting there. And so you can push back a little bit on that. But if they open the doors for community groups, they cannot say, sorry, your religious group, you can't meet here. And so this is a remarkable opportunity, I think, to build relationships with school officials. We'll get to that a little bit more later, and to build relationships with students. I know a lot of youth pastors may go and have lunch with students, and you can certainly invite them to a community group that meets at the school. And so that is something that's available to Christians and other people of faith certainly as well. to meet at school. So that was kind of the first category. I kind of put those together: student clubs, community groups, but ways that you can have meetings on the school campus. The next one I'd mention is students. What about students themselves? And there's a famous case that talks about how students do not kind of leave or check their First Amendment rights at the schoolhouse gate. The Constitution says that they are persons entitled to protections of the First Amendment, and this would be true in state law as well. So what about students? What can and cannot they, what can they do? What perhaps would be an issue that they might run into if they are attempting to live out their faith at school? The basic rule is that a school may not prohibit student expression during non-instructional instructional time unless it, and here's number one, materially and substantially interferes with the operation of the school, or two, infringes on the right of other students. I'll give you one example. Perhaps this is an easy one, but if a student were to stand up and began reading from the Bible and attempting to evangelize classmates during the middle of a test, the school would probably say, look, this is interfering with the operation of the school. There's, other opportunities for religious expression. And so that would be a situation where the school would probably lean into this materially and substantially interfering with the operation of the school. As I mentioned, the Supreme Court has explained students in school as well as out of school are persons under our Constitution. They are possessed of fundamental rights, which the state must respect. So a couple of ways that works out is that students may express their beliefs in an assignment if it's relevant to the assignment. This would include also class discussion. And I hear stories from time to time of students that are being told, hey, you can't share your faith, or they're writing an assignment about a particular issue and they include their beliefs in that assignment and points are taken off for that. That's incorrect. Students may express their beliefs in an assignment. Again, this is free speech. This is who they are. They get to express that if it's relevant to the assignment. They also may distribute religious literature and advertise events. Again, this would be, the school may come back and say, look, this is substantially interfering with the operation of the school if it's done in a particular way. But generally, students can advertise about various events in the community. And this would include something going on at church or at youth group. And so they can distribute that and advertise events. They also may pray during non-instructional time. Again, basically, as an individual, you have the right to do that. So, if everybody's gathered around, talking at lunch, there certainly would be opportunity to pray with a friend. And so what I have generally sensed in this space is this just like hypersensitivity about anything and everything you do. Could be a violation of the Establishment Clause. I'll get to the Coach Kennedy case here in a little bit, and I'm hoping that with the effect of that case, perhaps some of that hypersensitivity is going to change, and there's going to be a little bit more kind of common sense prevailing about with a school's violating the Establishment Clause. I mean, you're not establishing a national religion if you're doing some of these things, and so I'm hoping some of the hypersensitivity will go away. A few other things about students is they may wear religious clothing. That could be jewelry, it could be a shirt. Again, where the school may push back is if a shirt is kind of purposefully inflammatory, they may say, well, you're interfering with, substantially interfering with the operation of the school. That has to be juxtaposed to the First Amendment rights of the student. But certainly students may wear religious clothing. There may be a fact and circumstance analysis if it's more inflammatory, but generally they may do that. They also may attend religious instruction during release time. There's a U.S. Supreme Court case about this. And if the court releases students to go to various electives, that can include religious instruction. And they also may engage in religious expression at a talent show. So there was actually a case where I believe a student played a worship song at a talent show, and there was some issue with that was appealed. And the court said, look, this is the student's private expression. They get to express that at the talent show. So those are some just basic issues that come up when it comes to the students. And the general principle is, they have religious liberty. They can express their beliefs at school. And so we can encourage students along those lines. Now on to teachers. And teachers is one of the more difficult places to kind of walk through this because of some cases. There's one particular case called Garcetti, and if you want to study that, you can. That essentially says that in the K through 12 space, now there's greater freedom when you get into college and the university setting, but for K through 12, the state does have a lot of authority, a lot of power to tell teachers as the state's agents, kind of what they can and cannot teach. Now, I do think that Garcetti does interfere with teachers' First Amendment rights, but it is current law, and so I think there will be continuing attempts to try to get that particular precedent changed. Again, my point today was to just share where the law is. It certainly is something that I think we should look at and continue to challenge it, just how strong that is, that teachers, when they step into the school, should not check their First Amendment rights, just like students don't. But let me go through some of just kind of the general ways that this works out. Now, when the courts review cases of teacher speech, they seem to be concerned with two things. One is that a teacher, as the state's agent teaching children, is not specifically endorsing a religion, say Christianity, say Islam, and essentially saying, look, this is the state's position. And then the second thing that they seem to be concerned about is coercion. So that if the teacher is doing something, do students feel like they have to participate? Do they have to act as if they are the followers of a particular religion? So again, that seems to be, again, just where the courts are concerned. Are you endorsing religion? Or do you appear to be coercing students into your beliefs? And so with those thoughts in mind, students may form after-school Bible study groups, or prior to school, they can participate in Bible study groups. We talked about kind of those community groups. Teachers absolutely can participate in those groups. They can form them, and so they definitely have the right to do that. They also may teach the Bible for its historical, cultural, or literary value. This may often be done in a comparative religions class, or maybe you're talking about American history. And so teachers can certainly share about Christianity for its historical, cultural, or literary value. They also may pray with other adults. There was a case where a teacher was just praying in a break room. Maybe it was a lunchroom. There were no students present. They're just praying. Yeah, maybe they're talking to others about their faith. That's absolutely okay. This is their own private expression. It's not in the presence of students. And so again, there's this hypersensitivity about, you're violating the Establishment Clause, when it's like, look, I'm praying. I'm here in a break room by myself or with other adults, and the courts have said that's absolutely okay. Now, a couple of cases where this is kind of front and center, it is definitely impacting our culture. I'll give you a couple of examples. The first one is a teacher named John Kluge. I mentioned his case just a little bit when it has in the parental rights context, that was at least relevant to some of that discussion. But Kluge was a teacher in Brownsburg, Indiana, northwest of Indianapolis, and music teacher. He had students in his class that declared themselves to be transgender, and the school had a policy that the teachers had to affirm those students using their preferred pronouns and their chosen names. Kluge is a devout Christian, and he went to the school leadership and said, look, I believe that we're created immutably male and female. I believe that using these preferred names and pronouns is affirming or saying, it's a verbally saying something that is not true, and I cannot in good conscience do that. He asked for an accommodation to use last names, and the school allowed him to do that for a time, and so he used last names. And then the school came back to him and said, oh, by the way, we've reevaluated that particular decision, and you either get on the bandwagon and use preferred pronouns and names, or you can resign or be fired. And so he resigned over that. That case went up to the Seventh Circuit, and in a 3-judge panel, the judges ruled against him. It's the case is Kluge versus Brownsburg School Corporation. If you want to read it, very troubling in the sense that the Seventh Circuit held that his use of last name and his last names essentially stigmatized the transgender students. That case has now been appealed to the full, what's called an en banc appeal, to the full Seventh Circuit. So not just 3 judges, but the full panel. And there's a case called Groff that was heard at the U.S. Supreme Court. And if you listen to our episode on Faith at Work, Works to the Supreme Court, I go into more detail about this that would be directly relevant to Mr. Kluge's case. But again, here's a Christian public school teacher who just went to the leadership and said, I respect my students, I love my students, but I just want to be able to live out my faith. I want to be able to work in this environment, believing what I believe. And that was a bridge too far. And so this is certainly not the last word on this particular legal issue, but that is something that's going on now. There's another case directly relevant to this topic, which is Ricard versus USD 475 Geary County Schools. This has been out of Kansas, where a school district ended up paying a settlement of about $95,000 to a teacher because the teacher was told to use the student's preferred name and pronoun at school, but to use the legal name when talking to the parents. So basically, in her pleading, she said, look, you are telling me I have to lie. I have to deceive parents and basically withhold the information about what's going on at school. And I can't tell these parents, and these are people that I know and love, and why are we cutting out the most important people in this kid's life? And the federal court there, it's a district court, sided with the teacher. A couple of interesting things that came up is the school argued that FERPA, which has to do with access to educational records, prevented the school from, allowing the disclosure of this. And in a footnote, the court's like, no, actually, FERPA says you have to give parents access to educational records. Also, discussion about HIPAA. HIPAA doesn't apply to schools; it applies to medical facilities, and so this is a kind of a common issue that's going around the country of schools saying, well, if this kid comes in, says that I'm transgender, and tells us that they don't want the parents to know, then we can't, we can't tell the parents. And in this particular case, the Card case, the court sided with the teacher and said, you were forcing this person to violate their religious beliefs and being truthful to parents, and held on her behalf or sided with her, and then the school corporation sided, or the school corporation settled that case. And so again, that's directly relevant to this situation. It's developing. And for Christian school teachers out there, if you have questions about that, please do reach out to a Christian attorney. You can certainly reach out to us at the Good Citizen Project, as well as many others around the country. But this is one that's going to be very fact intense, as well as you'll want to look at what circuit or even what district you're in as this develops. I imagine it will someday end up at the U.S. Supreme Court. Another really key case when it comes to public education is the Coach Kennedy case. If you haven't followed this case, Coach Kennedy was a football coach out on the West Coast, and a new believer. He felt compelled to pray by himself at the 50-yard line. And kind of as we talked about before with like a student-led club, if a coach was to kind of lead that and basically tell all the students or all of the players, hey, you have to participate in this pregame prayer, the courts have essentially said that's some form of coercion. Again, I'm just sharing with you where the kind of the case law is. His point was, look, after the game, I feel compelled to go out there at the 50-yard line to just kneel down and pray. Thank God for, whether we won or we lost, just thank God for the opportunity to be in this position. And he was terminated over that. And the school argued, well, that, violates the establishment clause because there were a number of students that would join him out on the 50-yard line to pray. So this case went all the way to the U.S. Supreme Court. The Supreme Court said, look, it's his own personal prayer, and he has the right to do that. But more importantly, the court essentially struck down what was called the Lemon test. And you may be familiar with Lemon versus Kurtzman. This is the test that was so often used over the last number of years on some of these cases where there's kind of hypersensitivity developed to anything smacking of religion. Well, that must be an entanglement in between public schools or the state and religion. And so this case finally did away. I mean, over the years, one Supreme Court justice described it as a ghoul or like a ghost that was just kind of hanging around, around the land. So finally, lemon is done with, and it may take some time for the full effect of that to kind of come back to your local district. But this could have huge ramifications. It should have huge ramifications so that there's just not so much hypersensitivity over this. I mean, if we're not establishing a national religion or something akin to that, there should be, much more room for people of faith. As I mentioned, we're going to be, I think, in an increasingly plural America. So the Coach Kennedy case is really, really important. And it's, I think, going to have profound impact in this area as we move forward. The next group that I would mention would be parents. And of course, over the last year or two, we have seen parents kind of come out of the woodwork. Certainly some of the reporting from Virginia, where there was an important case where a teacher named Tanner Cross kind of stood up at a school board meeting and exposed some of what was going on. And there was a huge controversy over that. That played a part in an election there in Virginia. And so there's a lot of talk about parental rights and involvement. So what are the rights of parents vis-a-vis public education? So a few things you should know. First, the parents have the right to the care, custody, and control of your child. We did do a podcast episode on parental rights, and I went much more deep into this topic. You can go back and listen to that one as well, why parental rights need to be defended. But just kind of, especially vis-a-vis the public school, parents do have the right to direct the upbringing, the education, the mental health treatment of their children, barring abuse and neglect. The case law, federal case law, basically just affirming what's been true throughout the human experience, is that parents know best for their kids. And so they have the right to do that. They have the right to access school records. I talked a little bit about a federal statute named FERPA, where they can access school records. They should be in the loop on major decisions related to their children's well-being. And then they do have the right to opt out of sexual education. Now, this would be true in Indiana. Most states have kind of an opt-out, so there'll be a notice that is sent out, and then you have to say, hey, I want to opt my child out of it. There are some states that there are opt-in states where the notice will go out, and only the kids where the parents opt into that training would be there. Of course, sexual education to become a flashpoint because it includes not just the talk about the birds and the bees, perhaps, but more about transgender ideology and theory, these types of theories, this gender ideology, transgender ideology, those sorts of things. So that's become a flashpoint. Now, a couple of things that are going around the country, I'll use Indiana laws as kind of an example, but they're also going around the country. For example, here in Indiana, it was HB 1608 that passed out of our legislature. There was also a similar law in Florida. The one here in Indiana was essentially that no sexual education could be taught in between kindergarten and third grade. Seems to be pretty common sense to me. Let's focus on math, teaching arithmetic, whatever else, science. Why would we be going into these topics? Also, in this particular law, there's a requirement that if a student wants to change their record, wants to change their name, then at least one parent would have to be notified within a certain number of days. So addressing some of those issues. Also, I've been a lot of concerns about, well, what kind of books are our kids accessing? So there's a movement around the country. In Indiana, it was HB 1447. If you want to look at the text of a law like this, this would have to do with parents can access. What are the kids checking out? What's available to students in the library? We've mentioned the Cox case before, and this was a family here in Indiana that had their child removed from their custody because they could not in good conscience affirm that child's transgender ideology. And so we're seeing around the country a big move, again, kind of the LGBTQ movement versus parental rights. Last count that I heard, though I think there are 2 states that have recently signed similar bills, but a number of states, maybe 17 or so, have some law that essentially protects what they would call gender-affirming care. And some of the most concerning provisions in these laws is that essentially if a minor makes it to their state essentially they will interfere with the custody of the parents. They will, and quote unquote, protect this child from their parents and make sure that they get the quote unquote gender affirming care. So these are really alarming developments that are happening kind of right now. These are hot button issues, flashpoint issues. And so parents do have the right to the care, custody, and control of their kids. They have the right to access their records. They have the right to address sexual education, what's being done. So a couple of things that I would encourage parents to think about if they're concerned, if you're concerned about your local school district. One would be accountability. Parents generally have the right to review curriculum, to know what's being taught in the schools. So basically, standing up for that, making sure that you're watching, tracking what's going on. Another important thing is transparency. You can submit Freedom of Information Act requests. You can go to school board meetings. You can make sure that you're cued in to what's going on. That's important as well. And then certainly choice. There may be a moment or maybe a time when a particular school corporation for your kids, things become so charged, they're so ideologically driven in one direction that maybe there is another option. Now, not every state has great choice scholarships or voucher programs, but a lot of states are certainly bumping those up. Arizona comes to mind. Indiana just upped its school choice or voucher program to 400% of free and reduced lunch. So almost everyone in the state, as well as removing any pathways. Before this, kids would have to go to, say, 2 semesters of public school before they could qualify. There were other ways, but that was one. So just a couple of thoughts for parents there as we're thinking about parental rights. All right, so that concludes kind of our review. Maybe that wasn't too brief, but I did want to dig into that. I know that was a lot of information. Hopefully, wherever you are, maybe you're a church leader and you're maybe interested in a community group. Maybe you're a teacher. Maybe you have kids in the public school. Maybe you're a student. You can kind of grab the information I shared about those categories. So what would we do next? All right, because that's some of the case law. Those are some of the developments in this area. What do we do next? And I want to fall back to our good citizen plan. We talk about this a lot, but think about it in this particular context. The plan, if you're new to the podcast, maybe hadn't had a chance to pick up the book or hear us kind of go through this before. We want to be good citizens in a sense that our first and ultimate allegiance is to Christ and his kingdom, but then we want to be impacting our own zip codes, making a difference here. So being a good citizen means we review our role as citizen biblically, but also legal rights. That's what we're kind of doing in this episode. But the next one is to offer prayer for and build relationships with officials. What we've been doing at the Indiana State House, what many of my colleagues are doing around the country, what I'm encouraging pastors all over the United States to do, is to go build relationships. If you're going to make a difference in the community, certainly your representatives, your senators are important, but also the leader, maybe the superintendent of your public school corporation. This would be a key relationship to build, to meet with them. If they're comfortable, pray with them. Ask them kind of what's on their heart. How can you be a support to them? But then also asking, and here's the next part of this, offer solutions and partner with officials. So what are some of the key needs? Certainly the mental health issue, one that we talk a lot about in our community impact plan, is one that public schools are really wrestling with, trying to respond to. And I know of at least one example of a church that has partnered with the school where the school counselors are so overwhelmed that some of the pastors are just volunteering to essentially be mentors to help with students that, as the school counselors perhaps can deal with the most difficult situations at school, they can send some of the other kids that are just seeking some help and encouragement to these other individuals that are volunteering. And so that would be just, how can we help? What are some things that we can do? And then if you do those well, it does set you up for doing the hard work in public life. There are strong disagreements in this space, and I don't want to de-emphasize that. There are very strong disagreements. There's certainly tension here, but I think we need to lean into that tension. 90% of the kids in your community are going to public schools. That is a place where we should not just be completely absent. So are we doing the hard work in public life? Mentioned before, kind of the governor's big three of foster care, the drug crisis, mental health. These are all things that our public schools around the country are wrestling with. We mentioned the community impact plan. We did an entire episode of kind of going through that. I encourage you maybe listening to that mental health part of it or piece of it if you're looking for more inspiration for what you could do in your local area. And then I always try to sum up what I say with just kind of a phrase. And here it is. The best way to defend religious freedom is to use it. The best way, I would say, to defend parental rights is to use it. It's easy to try to offload some of these things and, all right, the public interest groups or the individuals at the state house or Christian attorneys, they're going to be the only ones that can impact that. And that is just simply not true. I am encouraged by seeing a number of parental rights groups start around the country. I think we as Christians will have our greatest impact in our own zip code. And so the local school board is a place that you could run. It's a place that you could really make a difference. Sometimes we feel a little powerless when we're thinking about Washington, D.C. Well, what about your local school board? What about your local school? How could you make a difference there? Before I finish, I did want to note the disclaimer here. The presentation is designed to provide accurate and authoritative information regarding the subject matter covered. That entire disclaimer is right at the end of the episode. These situations are very fact intense, so I'd encourage you to reach out to an attorney with further questions. A couple of questions that I've received just to kind of close out the episode. One would be, as a school teacher, what would be perhaps the best way to live out your faith at school? And we talked about the student clubs, and actually was speaking to a teacher at a public event about this recently. And student clubs are difficult because there's that non-participatory role that you have to play. I think you can still be a great encouragement to students, especially in the high school space, if they want to start a Christian club, and you can be that non-participatory teacher or faculty member. But it does appear to me that, look, a community group, maybe teaming up with something like CEF, maybe Fellowship of Christian Athletes, if you have whatever community group that you might want to align with or jump in with, this, I think, would be the best way to step in because of the fact that you can kind of take off your teacher hat, put on your I'm a fellow believer hat, and teach the kids, fully participate in that setting. I thought that was a great question. Another question has come from individuals that are, in leadership in public school corporations, and especially in some of the circuits in the United States. The Seventh Circuit is one example, that you have case law, which essentially has taken what is called the Bostock case, which held that in Title VII, in the employment law context, that the word sex in the Civil Rights Act actually means sexual orientation and gender identity as well. That was in an employment law case. But essentially what the Office of Civil Rights, what the Biden administration has done is to extend essentially what was held in Bostock into the Title IX space, or into the employment space, or into the education space. And in certain districts, like in the Seventh Circuit, we have a case specifically addressing bathroom usage and of an individual that would declare themselves to be transgender. School attempted to use just a gender-neutral bathroom, said please use that, and the Seventh Circuit ruled against that school. And so in the Seventh Circuit, there's some very difficult case law that public schools, I think if I could describe their position, they feel caught, because if they do one thing, you're going to get sued by this group over here from the LGBTQ movement. But if you go along with some of what the LGBTQ movement is saying, you're going to have parental groups that are rightly frustrated with what's going on and even suing you over some of these things. And so I think if I could describe what a lot of public school administrators are feeling, they just feel kind of caught in the middle. What do we do? And one of my recommendations to public school administrators would be to find school counsel that understands that tension. Because a lot of what I'm finding in this space is that a number of the law firms or attorneys that represent public school corporations often just lean into the movement, into the LGBTQ movement, into transgender ideology. And so where there would actually be an open question, for example, the implementing what was actually decided in the Bostock case in the employment context, and just naturally, automatically dragging it over into the education context when there is no act of Congress, there is no Supreme Court case that says that. That they're just going to push that over and say, you need to be risk adverse, when there actually is room for disagreement there. There's actually differing opinions on how that would work out. And so one of my encouragements is to find legal counsel that may take some searching, that understands the law and can help the school corporation navigate what's going on, but without just entirely throwing up your hands and just surrendering to transgender ideology when these cases are still being worked out. Much of this is very new in federal jurisprudence. And so that's been one question that's often come up. Maybe that's you. Maybe you're in that situation. Maybe there's someone in your church that's in that situation. So that's something I would encourage them to consider. The last question that I wanted to mention, just one that I received, and I always appreciate people asking me questions, is essentially, somebody pulling up a primer, maybe a New England primer, and reading what was in American education, say even 100 years ago, maybe a little bit further back, but the actual references to Scripture, the explicitly Christian nature of that public education, and kind of the question of, well, how do we make it back there? Like, how do we make it back to where we were before? It's always an interesting and so a difficult question to answer. I consider myself a hopeful realist. I have hope because I believe in Jesus Christ. He got out of the tomb. But I also think we need to be realists in the sense that it's impossible to impact and change a culture unless we fully understand where we are and kind of look where we are in the face. And one thing that I hear often is people marking the decline of the United States by taking Bible reading and prayer out of schools. Now, am I a fan of Bible reading and prayer? Of course. But having kind of a civil prayer, and certainly the word does not return void, but just reading a passage of Scripture before school starts, having that pulled out of schools and saying that was the end of the United States and that marked our moral decline, I think is a bit simplistic. There are certainly many other factors, including the church's failure to make disciples. Right? So there's a lot of factors kind of bound up in that. So my basic response to this question: how do we get back to where we were before? First of all, I think the primary hope there is spiritual renewal or revival in the United States. I don't think we can just rely on attorneys and politicians. So, all right, you need to change the law so we can get back to this good spiritual place. Right? Again, I think that spiritual renewal, spiritual revival is the most important thing. But I will often mention that I am a part of what I would term a church-led, state-based strategy for renewing America. And that is in our states, in contrast to D.C., where often it's just kind of stalemate. And certainly we still need to engage in D.C. It's a both and, not an either or. But where the greatest opportunity and the greatest energy, it seems to me at this time, is at the state level. Where we can be the laboratories of democracy, where we can have policies that are in stark contrast to other states and say, look, this leads to flourishing, and we can prove that. And so I think, again, it's kind of a both and. One, the church needs to be the church, and that's one of the things I'm encouraging. How do we get back there? Well, one, I think what is the goal? The goal is to have more people come to Christ. And because, and we've talked about this before, because they become disciples, people who wholly follow the way of Jesus, they just so happen to become good citizens. And that a flourishing United States where people are coming to Christ, they're living out those beliefs in an increasingly plural world, and that has impact, kind of a steamrolling, growing impact in a community, and that's what makes a difference. So I don't know, what does it take to get back to where we were before? I don't know if that's kind of the best question to ask. I think the better question is, how can we make disciples who just so happen to be good citizens, and then how can we go out, impact our zip codes in such a way that in 30 to 40 years we transform our city, state, and nation through the power of the gospel? I think that's the goal It's easy to get caught kind of looking in the past, lamenting what's happened. That certainly wasn't the spirit in which that question was asked. But I think that's the plan. That's where we go from here. So a little bit of a longer episode today, but I did want to dive into this topic. Again, 90% of American children in public schools. How can we, as Christian citizens, make a difference in that space? Well, one concern is certainly what are the legal nuts and bolts. We've gone through that. If you do have questions, would be happy to field those. Josh@goodcitizen.us, Josh@goodcitizen.us. But that's what you need to know about constitutional rights in public schools.